All right, we're gonna get started, everybody here. So thank you for coming and welcome to Squire here. I'd like to say a few things. I'm Andrew Folks, working with the IEP as the Knowledge Net volunteer. I'm also an associate at Frankfurt Clinic Finance Sales. So moonlighting is your Knowledge Net chair for the next year and a half. So first of all, thank you, Squire Patent Box, for hosting here and at the beautiful offices in Dublin, LA, and the Mendocino and everything. Thank you to people showing up here, which is, I've seen some new faces and some old faces, so I love that. And the people joining us virtually, I'm glad you could take some time out of your busy day to hear about AI and marketing. So I will pass it off to Alan here. Oh, and also the CPEs here, you will get an email after. Be sure to go check your account on the IPP website to make sure that is inputted. If you have any questions, you can feel free to reach out. So now here's Alan.
Yep. Hi, Alan Friel. I'm the global chair of Squire Patent Boggs Global Data Practice. We have 80 lawyers spread out amongst almost 20 offices, and I think 15 countries. My colleagues, my LA-based colleagues here today are going to be doing this presentation. A couple housekeeping things. Bathrooms down the hall just past the reception. For CLE, people in person, be sure to sign in and put your email address if you want to get a certificate. For the online people, there will be a code at the end. And again, if you want a certificate, we need you to submit that. And we already talked about IAPP credits, right? Okay, so with that, I'll turn it over to Kyle.
Yeah, thank you. So a little bit more housekeeping, just to get out of the way. We're recording today's program. I guess we're trying to avoid civil lawsuits, so we're going to mention that. During the presentation, all virtual participants will remain in listen-only mode. We will be circulating the materials as well as the recording and dates following this session. For our virtual attendees, if you have difficulties, please send a message via the Q&A panel, which is located in the lower right of your screen, and ask for assistance from the host. This will be picked up by our IT support team. We have scheduled time to answer questions at the end of the session. Please use the Q&A function and select all panelists to ask a question directly to our team. If we're unable to answer your question due to time constraints, we'll be happy to follow up with you. For those of you who require CLE credits, please note that Arizona, California, Georgia, New Jersey, New York, and Ohio are approved or pending for 1 hour general technology or cybersecurity credit, and we're going to give you a code at the end of the session. So thank you again, everybody here in person and virtually joining us. I'm Kyle Pfaff. I'm a partner here in our Los Angeles office and our data privacy, cybersecurity, and digital assets group. I have a broad data privacy and AI focused practice and a substantial specialty in a lot of things we're going to be talking about today. Digital advertising, artificial intelligence. On the digital advertising side, I represent a lot of large brands, publishers, as well as ad tech intermediaries. And on AI, I represent both companies that deploy AI as well as developers. Pass on to Neelu.
Hi, everyone. Thank you for joining us today. I'm Neelu Masacci. I'm a senior associate here in the Los Angeles office of Squire Patent Boggs, and I focus my practice on a lot of the same issues that Kyle just mentioned, data privacy, consumer protection law, advertising, a lot of which we'll cover today.
Hi everyone, my name is Giselle Tomenbeg. I'm an associate in our data group in the LA office. In addition to helping Kyle and Neelu with the issues that they tackle with clients, I also support our clients in the healthcare industry and digital healthcare space in their privacy needs. Great. So on the screen is our agenda today. We've reserved some time for questions at the end. For the folks who are here in person, we also plan to stick around at the end of the program to answer any other questions that you may have. So feel free to flag us at the end for any questions. We are covering a lot of ground today in the next hour or so, so I'm going to hand it over to Kyle to get us started.
Yeah, so what we're going to be talking about today is marketing, data monetization, and AI. And I think, sort of setting the stage for why we're here. I think from industry changes and the privacy laws that have been passed by, 20 states now. But basically, I think, there's a lot of things that have happened, such as Apple's transparency framework, and then Google's sort of cookieless future teasers. It's going to happen. It's not going to happen. Now they finally pulled that. But in response to those things, companies, whether they're consumer facing or B2B, started doing a lot more things with data, collecting a lot more, and doing things that are, arguably more intrusive as viewed under the lens of privacy laws. Companies are collecting more data and doing more with it. Now, with respect to AI, I think it's the buzzword. It's been the buzzword since, November 2022 when ChatGPT was released, and that really hasn't stopped. Basically, pretty much every single one of our clients is either using AI, exploring the use of AI. A lot of companies are starting with generative AI, but it was beyond that. But use cases abound, and so we're going to talk through a couple of different use cases today, and how they affect consents, opt-out rights, and other regulatory requirements.
All right, so we're going to start off our presentation giving an overview of these opt-out rights under the 20+ state laws that Kyle mentioned. You may be familiar with concepts of sale, sharing, targeted advertising, and a new concept that we're going to be diving into is automated decision-making technology. Consumers have the right to opt out of certain uses of automated decision-making technology. And what's interesting is that when it comes to using automated decision-making, which I'll refer to as ADMT in our presentation for short, is that there's also a pre-use notice requirement, which essentially means providing consumers a laundry list of information associated with that ADMT before you start to use it. And as we'll discuss, this could be a de facto implied opt-in rather than an opt-out of the use of the technology. There's also other opt-outs, such as for sensitive personal data processing under some of the laws. And we're going to dive into these in our presentation. So what is automated decision-making technology? To be able to provide notices to consumers that are complete and accurate, and then also the proper corresponding opt-out rights, it's important to understand what automated decision-making technology encompasses. And the definition is rather broad. When you really break down each term within the definition, those also are defined. And it helps us understand, okay, what sorts of technologies that businesses might be using are actually covered by this concept under the law. For example, ADMT is defined to include profiling. In the definition, there's also the concept of technology, and technology is defined to include artificial intelligence. So if we really break down the definition of ADMT, we see that it's already encompassing things like AI, profiling, and then also concepts like substantially facilitate human decision-making. What does that mean? That's also defined in the proposed CCPA regulations, and essentially means that the output of the technology is the main factor that's helping a human make a decision. So the takeaway from this slide is ADMT is defined broadly, and a lot of everyday technology that businesses may be using are encompassed by this broad definition and should be considered under the scope of the laws. Now moving on to specific use cases of ADMT that require providing consumers an opt-out. We've summarized them here on the slides, but we're going to focus today on using ADMT for profiling a consumer for behavioral advertising, and then also to train ADMT technology. But I'm going to give a little overview of the other concepts just to demonstrate how they're going to have a role in a business's processing of personal information in relation to these ADMT technologies. So for starters, there is an opt-out for using ADMT to make a significant decision concerning a consumer. So what does that mean? A significant decision concerning a consumer, for example, is the provision or denial of certain services to a consumer using ADMT. So for example, housing, insurance, lending, educational or employment opportunities. If you're using ADMT to make decisions that impact these areas of consumers, then consider, okay, so the consumer may have the right to opt out of these ADMT uses. Then there's also the use of ADMT for extensive profiling, and this encompasses things like worker educational profiling. Is there an ADMT that's systematically observing an employee in the workplace or a job applicant? And if so, consider now whether the opt-out comes into play. Then there's public profiling. So an example of this is a business may track a customer throughout their physical store using Wi-Fi signals. This can be an example of publicly profiling a consumer and then using ADMT to maybe send them targeted advertising. The takeaway is that ADMT and its uses have very broad implications. It touches HR data, it touches publicly profiling consumers, and as we're going to discuss, it has broad impacts on behavioral advertising to consumers. Okay. So you may be familiar with these concepts of sale and share under these US laws. Some of the states define a sale of personal information to require monetary consideration, and others do not. So what impact does this have? When you consider it in the context of targeted advertising, it shows that it's very use case specific. You need to apply it in consideration of the state law in play, consider whether or not monetary consideration is required, and then the impact that has on targeted advertising. Sharing for cross-context behavioral advertising is another concept under the CCPA, and it's specific to the advertising context. And the other laws have a similar concept. It's called targeted advertising. So when you break down the definitions of CCBA or cross-context behavioral advertising and targeted advertising, there's a lot of overlap between them, but then there's also some nuances, which really demonstrates why it's important to analyze these different concepts across the laws. For example, while both concepts relate to sending targeted ads to a consumer based on a business's first-party data, their own data, as well as third-party data, so data collected from a consumer's activities, maybe on another website or from third parties, both laws touch on first-party data and third-party data. But then there's also some distinction. So while a consumer can opt out of both of these types of advertising, when they opt out of targeted advertising, it's sending communication to the business that they can no longer send targeted ads to a consumer either internally, so based on that business's own data, or by making the data available to a third party to send targeted ads. Whereas for cross-context behavioral advertising, which is the concept under California's law, it doesn't affect sending internal ads. You can still target internally, but you cannot make the consumer's PI available to a third party for targeted ads. So the takeaway is basically that because the definitions vary under the different state laws, the effects that opt-outs of advertising have on a business's ability to send targeted ads to a consumer vary based on which law is in play.
And one distinction I would note there is like the internal processing of personal data for the purpose of targeted advertising, like taking data and then creating advertising segments, different things like that companies might do internally. Targeted advertising opt-out under the non-CCPA laws would extend to that sort of internal processing. But a sharing opt-out under CCPA only applies to disclosures or making available data to third parties for the cross-context behavioral advertising. So the sharing opt-out does not extend to like just the internal processing, like creating segments, doing analytics to figure out who do we advertise to.
And then now turning to profiling for behavioral advertising. So I mentioned earlier that under the proposed regulations we have from the CCPA, ADMT, so automated decision-making technology, is defined to include profiling. And then profiling has its own definition, which we have here up on the screen, and then profiling for behavioral advertising. Behavioral advertising is also defined. The key takeaway here is that when you look at the definition of profiling, in particular, it says using automated processing of personal information to analyze aspects of a person, such as their preferences, their interests, their location. And when you think of this in consideration of targeted advertising, we see that profiling's definition encompasses sending targeted ads because you're evaluating things like a person's interests, their location, their preferences to send them these targeted ads. And then when we look at the definition of behavioral advertising, it encompasses sending targeted ads based on not only first-party data, but also third-party data. So in the two main takeaways I would say are that this opt-out of profiling for behavioral advertising, which comes into play when using AD&T, extends to both targeting ads based on a business's own first-party data and also the data of a third party. And the opt-out is similar to the targeting advertising opt-out that I mentioned on the last slide, in that it applies to a business's internal processing, so internally advertising, sending out targeted ads to a consumer, as well as disclosing that consumer's information to a third party to send targeted ads. So the opt-out is broad and it applies to not only a first-party data, but also third-party data that a business may use.
Yeah, so I think like the breadth of this definition is really striking, based on what, Nilu said. I think the goal of the California Privacy Protection Agency here is to align the opt-out rights under the CCPA to be more like the targeted advertising opt-out rights in the other states, to apply to that internal processing for advertising purposes. But the extension of it to first-party data. I mean, if you think of examples like, we're all familiar with like getting reminders like, hey, you left something in your cart, or like, hey, you're looking on a retailer's website, like, look at these, you're looking at a current, shirt that you like, but you also previously looked at these 5 shirts. Technically, like that little message or like, banner at the bottom that shows you the stuff you previously looked at could be considered an advertisement. It's certainly something like based on your interest. So that could be considered profiling for behavioral advertising. Even things like, like location-based push notifications, like you go near some location, an app is collecting data about where you are, sending you an ad based on that. If it's solely based on first-party data, that could also constitute profiling for behavioral advertising and subject to the opt-out. So it's the breadth is pretty, it's extremely broad, and it's going to be a much broader opt-out right than currently exists under the CCPA and really under the other state laws as well, because of the bringing in first-party data only ads as well.
Great. The pre-use notice under the proposed CCPA regs proposes to require businesses to provide consumers with a pre-use notice before the business processes the consumer's data using ADMT. The notice must be drafted conspicuously or presented conspicuously, drafted in plain language, and among other things, inform consumers of the use of the technology and also their rights as to that data that's processed through the technology, including their opt-out and access rights. Earlier, Nilu alluded to this notice potentially being a de facto opt-in. Let's think for a second how your company might operationalize this. In general, right now, when companies, when your website uploads, cookies fire right away at upload. The way the regs are drafted currently seems to contemplate that prior to the cookies deploying, the pre-use notice should be displayed. And so for your technical teams, that really, further complicates their deployment of your website. So on the screen are the technical requirements you need to factor in when building your pre-use notice. As discussed, the proposed regs contemplating permitting separate notices for distinct or separate uses and consolidated notices for similar use cases. The pre-use notice must be drafted in plain language, and then in addition, it must also include certain disclosures like the consumer's rights with respect to the data you're processing using the technology. And then businesses must also inform consumers via the pre-use notice that the business won't retaliate against them for exercising their opt-out or their CCPA rights. Finally, if you have additional information about how the technology works, you must provide that in your pre-use notice. So with this list, numbers 1 through 4 contemplates like a first layer of the notice, where you provide the high-level disclosures about the technology to the individual. And then number 5 is the additional information about how your technology works. And that probably could be presented in a hyperlink that kicks out to a separate page where the consumer, if they please, could read more about it. The key takeaway here is, if approved, the proposed regs will require businesses to provide consumers with a lot of information about their use of ADMT. On this slide, Kyle is gonna walk us through an example of what this notice might look like.
Yeah, so we drafted this notice, as a, sample pre-use notice that the company might use to provide the notice through a cookie banner, assuming they're, using profiling for behavioral advertising, involving cookies and other tracking technologies and other things that we're gonna get to. But I mean, I think maybe a show of hands for the folks, who are, in-house in the room. Raise your hand if your business stakeholders are going to look at this and just throw up because of just the length of it and the disruptive nature of it, and just it's going to scare people away from their website. I saw a lot of head nods. I see, yeah, that's a hand raise.
We're getting a lot of hand raises on.
Yeah,
Here.
we're getting a lot of hand raises on WebEx. So yeah, I mean, this is the level of disclosure that, just taking basically the bare minimum requirements under the regs that Giselle went through, items 1 through 4, we use automated decision-making technology for X, and you have the right to opt out. Click more info for how to opt out. You have the right to access, etc. And so, in my experience working with clients, business stakeholders typically don't care if something can just go in a privacy policy. But one of the biggest, negotiations or discussions we have with business stakeholders between legal and the business teams are do we really have to put this front and center when somebody comes to our website or when they visit our app, et cetera? So there's just business challenges, and I totally recognize that. And certainly companies have the ability to make risk-based decisions to not go with something, that meets the requirements. But this is just to outline and showcase how extreme these requirements are. I think other things that come to mind when looking at this is adding on top of this, there's still the right to opt out of sales, the right to opt out of sharing, opt out of targeted advertising. So if somebody clicks more info, they're taken to a cookie preference center. Explaining that to a consumer and the differential rights that they have, it's going to be really confusing. And doing that in a clear way. But back to the point of just the voluminous nature of the notice. Think about other things that companies use cookie banners for. Certainly at the moment, none of the state privacy laws require you to have a cookie banner. Some companies have decided to do that, as a conservative approach, pre-collection notice. A lot of companies now are using a cookie banner to mitigate risk under SIPA demands and lawsuits. And then some companies do it to get as close to a click wrap with their terms of use as possible, by continuing to use our website, you agree to our terms of use. So just layering this on top of other things you want to or would like to or need to accomplish through the use of your cookie banner, that's just going to add to it. And so this is just sort of food for thought of these are things that you're gonna have to like socialize with your business, like these are coming. And they're pretty terrible. I think the other sort of, cookie banner certainly isn't the only context that this may arise. Think about it in the context of like somebody getting on your mobile app for the first time. You'd have to provide a similar notice, cookies and tracking technologies aren't the only, web-based aren't the only thing that you may be using for profiling for behavioral advertising. You might have SDKs on your website. Companies collect email addresses and then, use those for targeted advertising purposes through ad networks, through social media networks. And so that will arise in that context too. You're gonna have to provide notices like this in your app, along with like the barrage of other notices that you have to provide, like the Apple ATT pop-up, location consent pop-up, all those sorts of things. So it's just, notice overload to consumers. And yeah, these are things that business teams don't like. And so we wanted to make everybody aware of like, this is coming, but here's what it might look like. So let's talk about like, different things that companies do from like an advertising perspective and, the potential opt-outs that are going to apply, considering we have like, all the ones Nilu went through. So looking at like advertising specific, I think let's first talk about like the scope of like advertisement and like what, when the law says targeting advertising to a consumer, what regulators might consider advertisements. Like, obviously I think traditional banner ads on websites, mobile apps, ads on CTV, that's clearly an advertisement. I think if you look at like the plain meaning of advertisement, like the dictionary definition, and then, how advertisements are defined like under different legal schemes, marketing emails, marketing texts, marketing push notifications, especially if you're creating those based on, if they're targeted to people based on personal information, like the cart reminder I just mentioned, like that's based on the fact that someone looked at something, put it in their cart, and then they left and didn't pay for it. That is probably considered an advertisement. Different things like that, or like the location-based push notification I mentioned before. So there's gonna be these differing opt-outs that apply to these different activities. And so, I think that the takeaway here is like, it's getting a lot more complex, and I think we as privacy lawyers are gonna have to like understand this stuff with like great particularity in order to advise, our clients, our business teams in a way that has a minimal business impact. There's probably, probably the easiest way would be to just provide a single opt-out for all of these things, but that may be really difficult from a technical perspective, and it's going to have significant business impacts. So you're going to really have to like roll up your sleeves and understand this stuff, like give your businesses really practical advice that's not going to kill the bottom line. And so I think sort of going along the lines of, I think the way that most companies are approaching the current opt-outs for like sale, sharing, and targeted advertising is through two mechanisms. First, through a CMP to address sale, sharing, targeted advertising that is occurring through cookies and other tracking technologies. And then second, through a web form or like another channel, like your toll-free number, to address opt-outs involving, the use of non-cookie data like email, phone number, any other data that you collect that you might sell, share, use in targeted advertising. It's not clear from the current proposed regs if that is going to be okay with respect to profiling for behavioral advertising opt-out. The language of the proposed regs signals that they contemplate like an opt-out. If you make an opt-out on a CMP, you have to apply it to like non-cookie information and vice versa. It's not 100% clear, but the way it's drafted seems to indicate they're thinking in that direction. And so I think that is like sort of the current state of like what the regs say. They Q1 maybe we'll see final regs, probably not, maybe Q2 next year. But that's the current state. So speaking of like tying a cookies opt-out to, when you get one through the CMP to like, non-cookies data, like email addresses, other data you have on people. Under the CCPA in Colorado, if you receive like a global privacy control opt-out, like the opt-out preference signal, universal opt-out mechanism, the technical requirement is that you have to tie the opt-out preference signal OOPS or opt-outs to the non-cookie data. There's not a specific requirement with respect to like, manual CMP opt-outs that you have to do that, but we understand that regulators do expect that. But I think it kind of remains to be seen with this profiling for behavioral advertising opt-out and where it goes. But yeah, I think, the takeaway here is like, this is getting very challenging and difficult from a technical perspective. And, we as privacy lawyers, we're gonna have to roll up our sleeves and understand this stuff from like a, legal and technical perspective to give some good practical business advice to our teams. I alluded to the opt-out preference signal and the universal opt-out mechanism, various states. We've got a table here that shows, the date by which the requirement will have to be heeded in various states. Colorado's just came into effect July 1. We've got 5 more states, Jan 1, and then, several more coming in through 2025 and 2026. I don't think I mentioned yet that there's, in the current draft ADMT regs with respect to profiling for behavioral advertising, there's no mention of the opt-out preference signal having to be applied as an opt-out for profiling for behavioral advertising. We think that's because they've probably looked at it and said, we don't have regulatory authority to do that based on the way that the mandate. But that's current state of the regs based on like the OOPS GPC stuff with respect to this profiling opt-out. Back to AI.
Back to AI. Okay, so for the requirements of the ADMT to be triggered, your technology must be capable of being used for a list of functions. For example, it must be capable of making a decision concerning a consumer, capable of establishing the individual's identity for physical or biological identification of the individual or profiling, and for generation of a deep fake. It's important to note that in addition to the California requirements for AI and ADMT, other states are now also starting to take a look at how companies are using AI functions for their business purposes. Colorado, for example, recently passed the Colorado AI Act, which regulates high-risk systems. So in the next slide, we're going to talk about an example use case using like a common real world scenario that all of us have seen. We're going to use a chatbot example to present an ADMT that's capable of making a significant decision concerning a consumer. Certainly, how companies deploy their chatbot technology commonly doesn't allow for that technology to make these types of significant decisions about consumers. For example, whether they're eligible for hiring or whether they're eligible for housing. But in this scenario, for purposes of our example, we're going to assume that it could be. So as you'll see in the language here, our disclosure regarding the chatbot includes all the requirements that are, outlined in the regs. So it's drafted in plain language, it discloses what the technology is, and then it talks about the consumer's rights with respect to that data processed by that technology. And it also tells the consumer, hey, if you exercise your CCPA rights, we're not going to retaliate against you. There's also a link there for the additional information about how the technology works in case the consumer wants to learn more. If you note here, the amount of text that's in this disclosure is pretty unwieldy. It's a lot of words in a small amount of space. But if you notice in this chatbot chatbot notice, it doesn't include standard disclosures that your company may want to include in the notice. So for example, your SIPA disclosures about recordings, as Kyle brought up earlier, that's something that you really want to include in this notice to protect your company against private action. But because of the amount of words here, would the consumer even be able to read it before they press agree to use the feature? And then, you'll notice here too, there's no link to your privacy policy, your, notice at collection is not there. And then there's also no reference to the application of your terms of use to the chatbot feature on your website. And so, this is just, to get everyone thinking that with how the proposed regs are drafted, they're seemingly starting to encroach on territory that was previously just a small notice regarding your chatbot feature. Now it's becoming really expansive, and it'll probably take up more space than what you intend for it to do. Next slide. So there are a lot of consent requirements under the state privacy laws. These are just examples of them. Sensitive PI is of course top of mind, but as shown on the screen, there are at least half a dozen other types of consents that are required under the laws. Failing to factor in the nuances between each of these opt-in or consent requirements could be consequential for your business's business risk, but also your compliance activities. In the next few slides, Kyle is going to go over secondary use cases.
Yeah, thanks, Giselle. So yeah, I think, data minimization and secondary use provisions, I think, they're in every single state law, I think, except for Iowa. It's a weird sort of outlier that's missing a couple of these things. And it's, kind of unlike, certain provisions in the privacy laws and different requirements, like privacy rights. If you get a consumer request, you have to deal with it within a time frame. And so it's less top of mind. But I think, as we'll talk about, I think it does, they're definitely worth a look and do present risk. And so I think the way to sort of sum up the data minimization principle in each of the laws is that, it potentially prohibits, certain collection and processing activities, even if it's, disclosed to a user in the privacy policy or notice of collection. And the CCPA sets forth a reasonable expectation standard that prohibits certain processing that doesn't align with the consumer's expectations. A lot of people probably haven't looked at closely at section 7002, but I point people to the flashlight example in section 7002. Then Maryland has probably the most draconian data minimization requirement that limits processing to purposes that are reasonably necessary and proportionate to provide a product or service requested by the consumer. And so that, if you read that in isolation, you say well, we can only provide, we can only do things with data that are reasonably necessary and proportionate to providing the service. Is targeted advertising reasonably necessary and proportionate to providing the service? Is using artificial intelligence, you taking personal data to train AI? I think there's a lot, I think, that we could dive into with data minimization, but we wanted to put that out there as food for thought. Take a look at this stuff. It's could be very consequential. I think we're going to talk mostly today about secondary use, and I think like I said, every state but Iowa explicitly requires, has these provisions. And basically what these secondary use provisions say is that you have to get consent for processing for purposes that are not reasonably necessary or compatible to specified or disclosed purposes. So purposes that you disclose in your privacy policy or notice of collection. So from a practical perspective, when would this arise? I mean, I think the first and most obvious one would be doing things that are not disclosed in your privacy policy. And so, that's, I think, the most obvious, where it would come up. I think another place where it really comes up is, and we've got another slide next that has a lot of the data monetization and standard use standards. I think we're going to skip over that one, but it's worth a look. I think where the secondary use issue arises a lot is, or could arise, is where, you know, companies are making changes to their privacy policy. And, you know, I think it's a common practice for companies to say, you know, we're implementing this new vendor, or we have this new processing purpose. Is it covered by our privacy policy? And then updating it and calling it a day. I think that because of the secondary use principles and all these state privacy laws, just, you know, making that update, calling it a day could present risk depending on what that new use is. So like the risk is, let's say, you know, a lot of companies lately have been, you know, adding, you know, I've been getting emails from a bunch of companies that, you know, I have an account with. So, you know, we updated our privacy policy to say, you know, or to use your data for training AI, things like that. So that basically means many of them are taking data that they previously collected pursuant to an old privacy policy that didn't disclose that, and then now using it for purposes that were not previously disclosed. That, you know, things like that could constitute a secondary use. And so I think it's as privacy lawyers, I think our job is to apprise the business that, hey, these provisions are here. We need to look at whether, you know, if we're going to apply this new use of our previously collected data, we need to analyze whether this constitutes a secondary use, because we technically may need to get consent for it. Now, certainly, like I said before, you know, companies are able to make different risk-based decisions. Your business may not decide to go down the consent route. But certainly, I think, you know, gone are the days where we just like update our privacy policy blindly and just publish it because of the, you know, secondary use. And in part because of, you know, every single state law has these provisions. The FTC is focused on it. In all of the, you know, health-related cases like GoodRx, BetterHelp, this was an issue. And then, you know, the FTC even put out a blog post like specific to like, hey, if you're going to start using data for AI training that you previously collected and your privacy policy didn't disclose that before, that could be, you know, deceptive under the FTC Act. And so I think, you know, basically the message is like, if there's a big change to what your company is doing with data, I think secondary use is something to consider. And, you know, just slapping on an update and publishing your privacy policy, it may be good enough. You know, I think there could be scenarios where like you did have some pretty good disclosures, broad disclosures in your privacy policy, and you can make new use cases fit. Could be risks with that, but you know, the analysis needs to be done, I think, is the takeaway, rather than just update, publish.
Okay, so keeping on this theme of consent, we have the TCPA, which is a federal law that governs sending text messages to consumers. And although it's a little bit of a stray from the privacy issues we were talking about now, we're covering it because it is a consumer protection law issue, and it emphasizes the importance of obtaining proper consent from consumers before marketing to them. So the TCPA specifically requires obtaining prior express written consent before sending promotional text messages to a consumer using auto dialers. There's a lot of litigation in this area. TCPA litigation is a very active issue, so it's important to consider, am I obtaining the correct consent from a consumer before sending them these text messages? There's certain language that you need to include at the point in which you're collecting a phone number, and there's additional language that you should provide in, for example, a text terms of use. One thing that we want to highlight here is that the FCC, which is one of the regulatory authorities for promotional text messages, has emphasized the importance of obtaining one-to-one consent. What does that mean? So it basically emphasizes that when a business is obtaining consent from a consumer to send them these text messages, that consent should only apply as between that business and that consumer. Some companies, for example, insurance companies, will collect a phone number to send marketing text to it. And at the point of collection, they'll say, you're providing this phone number to us and these affiliated companies to send you marketing texts. And there will be a list of 100 other companies that will also be using your phone number to send you the marketing texts. That goes against this principle of one-to-one consent that the FCC is emphasizing, which is that businesses should not be doing that. You should just be obtaining consent as between yourself and the consumer that you're going to be sending the messages to. There's also a few other things to keep in mind when sending these text messages. Consumers have the right to revoke their consent through reasonable methods. So this includes things like responding back stop or quit or opt out when they receive a marketing text message. But there's also FCC and FCC guidelines that provide more explanation as to what's considered a reasonable method. So businesses should be responding to these requests for opt-out and not continuing to send marketing texts when they receive them.
Yeah, so like even if someone, like the easiest and most obvious case, like the method is like if we've all said stop when we get a message and too many of them. But I think other reasonable methods would include like, I think there's cases like reaching out to customer service or like, getting an email saying, hey, opt me out of text messages are considered a reasonable method. So it's like connecting the dots between like customer service and, whoever's responsible for your text message program is key.
There's also a few other considerations. For example, we have something called the do not call registry, which is a consumer can sign up their phone number on this registry, and it basically informs senders of marketing texts and emails that they don't want to receive these marketing texts and emails. One question that comes to mind then is if I, for example, consent to receiving marketing text messages from company A, I give them my consent, I provide them my phone number, and they send me marketing texts. And then later I sign up for the do not call registry. Does that then communicate to that company A that I'm revoking my consent to receive text messages from them? If you take a look at the case law, it seems to suggest that it does not. It's not a reasonable method of withdrawing consent to sign up for the do not call registry after you've provided prior express consent to a business. But the key here is that you are actually obtaining proper consent. Otherwise, you technically don't have the proper consent to send those text messages to a consumer. There's also other considerations. For example, we have the reassigned numbers database, which basically means if I opt in to marketing text messages, but then my cell phone number is later reassigned to Giselle, companies that are sending these text messages should scrub against this list to determine if my phone number has been reassigned, in which case I have not consented, Giselle has not consented to receive marketing texts from company A, and she should not be getting those text messages. CAN-SPAM is the federal law that regulates sending email communications. So unlike TCPA, where opt-in is required, CAN-SPAM operates on an opt-out method. So business is sending a marketing email, for example, to a consumer. They should include the unsubscribe button within the email and stop sending marketing emails to that consumer once they unsubscribe. What's often overlooked by businesses that engage in marketing is what's bullet point number 2 here. So say, for example, again, with company A, I unsubscribe to marketing emails from them and they stop sending me those marketing emails. If they still maintain my email address though, and provide it to example, maybe Facebook, and then Facebook uses my email address to send me targeted ads through, for example, their custom audience feature or their lookalike audiences feature. Does CAN-SPAM extend to that sort of targeted advertising? If I opt out through the unsubscribe button, should the business then stop also advertising to me with other methods, still using my email address? It seems that this is the case, so businesses should be mindful of how this CAN-SPAM opt-out extends to other areas that they're advertising beyond just sending marketed emails. Okay. Here on the screen for those who require CLE credits, please use the code that we have here, data 1010, for your CLE credit.
It's a good sign that not everybody just jumped out and laughed after they got the credit.
Okay. And then now we'll pause for any questions that may have come up.
If anybody have any questions in the room first, we'll.
Like we got a couple from online. You want to jump with those, Andrew?
Yeah, we'll do it. So in reference to the block of text that you have provided on slide 13, the ADMT opt-out, somebody asks, knowing this doesn't look great, and if anything, it complicates privacy even more for the general consumer, do you think they will revise the law?
I don't anticipate that the agency will, cut back on requirements. There will be public comment periods and, the public will have the ability to make comments, and certainly I'm sure there will be scores of comments about these sorts of things. But yeah, I don't know. Alan, do you have any thoughts on like whether we'll cut it back or?
Well, I mean, the regs barely got advanced in a vote of 3-2. One of the opposing votes is now no longer on the board. She's actually here, Square Patent Blogs with us again. And it's unclear how that replacement is going to feel about some of these issues, but there was a lot of controversy about the ADM provisions throughout the process. And there's, some feeling that the staff got ahead of the board. Even some of the people who voted to advance it stated it didn't mean that they would vote for it in final form, but they thought the time had come for public comments. So I think we're in a situation where there's probably more likelihood for public comments to move the needle than there were with the first set of regs. And we did see them pull a bunch of stuff back from the first set of regs too. Now it's coming back,
Yeah.
some of it is, but I think the making comments is going to be an important use of time.
Yeah, and you think that the consumer confusion argument would like resonate with them? Maybe we should create a mock-up of what every single notice will look like and all the links and just how consumers' heads will spin in response to that.
And get Stephen Colbert to moderate that, a little animation.
Yeah.
Yeah, trying to read the mind of the board is a full-time job sometimes. We've got another question here from Jen Bang. She would love to hear your thoughts on categorization of some tracking technologies, such as LinkedIn, Google Analytics, and Facebook Pixels as the first party data by default by some of these third parties. How should companies operationalize the first party versus third party use of the data when some third party tracking technologies are deployed on a company website as first party cookies? That makes sense.
It does. So the first party cookie versus third party cookie, typically the only distinction is like where the cookie resides. Third party cookie is server side, and then first party cookies are like what they call client side on the browser. So even if like you have a first party cookie, but it's operated by, whoever, LinkedIn, any scores of providers, which became a lot more common after, Google started moving toward the third party cookieless future. A first party cookie still results in a third party collecting data on your website. So the analysis of like, whether it's a sale, share, implicating all of these different rights is the same.
You want to talk a little bit about restricted data processing, limited data processing?
Yeah, I mean, Alan asked if we should talk about restricted data processing, limited data use. So like in some of the big tech providers like Google and Facebook provide settings that if you enable them, they will act as a service provider in California. But, unless it's for, at least in California, cross-context behavioral advertising. So there are, settings that some big tech providers offer to avoid sale in some jurisdictions. And I think that list is kind of growing. I think even like, Pinterest and a couple of other companies are offering them. But yeah, I'm unaware like LinkedIn and that those sorts of companies doing that, but there's a lot of big tech providers that are offering settings to avoid the designation of, their collection of data as a sale by your company to them.
We have some housekeeping questions. Will the slides be posted? Anyway,
They will be shared within the next few days.
and then there's an email that was posted about the credit. They're asking if you can provide that email again.
The slide here.
Those are all the questions. I don't know if there's anybody in the room. Who have any.
Yeah, I would get any suggestions. One thing we really struggle with, especially in this area, is the privacy office and attorney communicating the requirements to the technology teams. I wondered if you had any resources or if there's any kind of way for privacy and like technology groups, professional organizations to get together to help kind of bridge that gap.
Yeah, I mean, that's a really good question. I think that, to some extent, there's so many different like slices of like privacy. There's like people that specialize in ad tech, people that specialize in different things. In certain industries, like, areas like ad tech, I think, groups like the IAB, the NAI have kind of served that role and like bring together people and help, put together technical specs based on legal interpretations by like the legal side of the house. In terms of like outside of that context, like there's, like the IPP, I think that's kind of one of their goals, like help translate legal requirements to technical administrative requirements. I don't know if I answered your question or how helpful that was, but.
It helped a little bit. Like, the opportunity for the attorneys in the room too, right? It's to help out companies in those conversations.
On slide 14, you referenced that you need to have an opt-out for targeted ads based on first-party data only. Wouldn't you also need an opt-out for targeted ads that you have in the second row? Am I misunderstanding that?
So in the second row.
The second row, you said there's a need for opt-out for targeting advertising. But under the first row, it said targeted ads on first-party data doesn't indicate that need for opt-out.
So in other words, the targeted advertising opt-out does not apply to ads based on first-party data only.
That's
correct.
And why is that?
Because if there's a slide, if you want to show a slide that shows the definition of targeted advertising, the opt-out is only invoked when the advertisement is based on data collected, personal data obtained from the consumer's activity over time and across non-affiliated websites and online applications. So
That's great.
yeah.
Okay, thank you.
Non-affiliated, it's like first and third party data.
Great, makes sense.
Great. Seeing no more questions, I want to thank you all for making the trek out here. This is what's going on as a picture. We look to see you again for our future acknowledgements.
Yeah. Thanks, everybody.
Everyone. Yeah.